Assalamualaikum and good evening to Puan Siti Zubaida. We are from Group 4 and today we are going to present about judicial exception, public policy or enemy character. But before that, let me introduce myself and my group partner. My name is Ahmad Razik Hilman bin Azrul Nazli. My matrix number is 01D820F1006 and my group partner Muhammad Rahimi bin Rabianto. His matrix number is 01D80F1007 and Muhammad Najmi Hakim bin Muhammad Ghazali 01D820F1016. So now let me explain about the public policy meaning. Public policy is the principal guide to action taken by the administrative executive branches of the state with regard to a class of issues in a manner consistent with law and institutional custom. So under public policy or enemy character, the court may also lift the corporate veil if the public policy requires it. A company assumes an enemy character if the person in control of its affairs are resident of an enemy country. The courts will examine the character of persons in control of the company and lift the corporate veil if they have an enemy character. In the next slide, my friend Muhammad Rahimi Berabianto will explain about the cases under public policy or enemy character. Thank you.
The relevant case for judicial exception of public policy or enemy character is Daimler Company Limited versus Continental Tire and Rubber Company Limited in 1916. In this case, the issue that arose was Continental Tire and Rubber Company Limited capable of acquiring the enemy character. Now, let's look at the facts in this case. Continental Company Limited was incorporated in England for the purpose of selling tires. All except one of the shareholders were German residents. The director also was German residents. Continental Tire and Rubber Company Limited supplied tires to an English company, that is Daimler Company Limited. During the First War, the English company commenced action for recovery of a trade debt. So basically, Continental Company Limited was incorporated in England and it was owned by the Germans. The purpose of the company is to sell and supply tires. During the First War, the English company, which is Daimler Company Limited, uh, did not want to have a business trading with Continental Tire and Rubber Company Limited, which means that the English company did not want to pay their debt to the German company.
The next slide is about the court decision for the case Daimler Company Limited versus Continental Tire and Rubber Company Limited 1916. So, even though the company was incorporated in England, it was considered as an enemy company because its shares were held by Germans. This happened during World War One, and the government has issued a decree against any business trading with the enemy, namely the German. So for the last slide is about conclusion. In conclusion, the court will lift the corporate veil if the company is in de facto control of the people of the enemy country, then it will also be considered as an enemy character, no matter that the company was incorporated in the country other than enemy country. There is a veil between the corporation and its member, director, shareholder, which protect its member from the liability of the company. In many cases, it seems like that the company and its member are the same. So, to determine that who is managing under the name of company, this veil is removed to avoid fraud. And that's all. Thank you.